Welcome to another quick Perlman legal video. Today I'm going to talk about something that we come across quite a lot. We have founders come to us, they're entering into an agreement with a new partner, and that partner has lifted something off of Seed Legal, or in this case, PandaDoc. Rather than use a template of what we would actually draft, I'm going to go through a very commonly used template that we then get asked to review to sort of red flag any sections of the contract clauses that our client needs to be aware of. A lot of the time, it's more a case of explaining what each of the clauses mean, making our client aware of how that affects them. And very rarely we do pick up certain red flags in contracts where we suggest that there'd be made an amendment. And just because we are working with another founder, when they've used a template like this rather than a lawyer, that process tends to be quite straightforward. In the rare case where we've had a founder who's got their own legal representative draft a founding agreement, it has taken a little longer, but that's not the purpose of today's video. So here's a couple points on a founder's agreement, and just right off the bat, this tends to precede the formal formation of a company. Couple of details that need to appear. PandaDoc's not going to get that sort of thing wrong. A little bit of a blurb on what the purpose of the agreement is, what it is that they are going to be agreeing on, what it is that the business would be doing, and really just that. And then once we go from there, there's a few things we start to take into consideration. So one of the first things that'll come to mind are basically the intellectual property rights. One of the founders may be, more financially savvy, maybe more entrepreneurial. The other, and this is often the case, and that's why I use the example, might be the one responsible for the development of software. The reality is, though, that with any startup, revenue doesn't immediately begin to flow in. And so one or both of the founders will still be working in some sort of capacity. What we've come across is that our founders then, or our clients rather, perform certain services that are closely related to the current activities of the business. And so we've had them ensure that that's not a conflict of interest. They're not competing with the business they're looking to form, and just have that be quite clear. All right, going on from there. So fairly straightforward. It needs to be agreed what sort of capital each founder will be contributing. Sometimes one won't be, sometimes both won't be. And then that will determine the rest of sort of how the business is structured, and potentially how decisions are made as well. Now, shares don't necessarily mean that you have voting rights. That needs to be agreed separately or in the agreement. If you're going to have a majority shareholder be the one who makes the decisions, that needs to be made explicit. Otherwise, it simply relates to how profits are distributed. It doesn't necessarily relate to the decision making. That would be something that would come up in the articles of association. And that's what happens once you actually registering the company, which, as we mentioned, a lot of the time, founders aren't doing that yet. Yeah, so this will just basically explain how that would work. It may explain as well how profits will be distributed. The next section, and this is one we do get a lot of questions on, is how equity is vested. Basically, this just means when one of the founders is entitled to their shares, and it's just a way of retaining that founder. So it makes sense if, just sticking with our example, one of the founders is a software developer and he's the one writing the program or creating the app or website, whatever it may be. And you say that his shares will have vested fully by the third year. And that way, should they want to leave in the second year, for one, the startup gets to keep a third of their shares, and also that tends to be a bit of an incentive for the the founder to stay. So it's just a method to retain a founder. Sometimes this is used with employees as well in a lot of tech startups, but in a founders agreement, it's specific to the founders, of course. So that it's basically the longer you stay up to a certain point, the more of your shares you're actually entitled to. Potentially, you could leave after 3 years and retain all of your shares in full, but no longer be affiliated with the company. And obviously the inverse is true. The shorter you stay, the less of your shares you retain. And that's basically how that works in as layman terms as we could put it. Management structure. This is fairly straightforward and is normally something that will have been informally agreed beforehand. And we might give a little bit of input on just suggestions and how they should draw up the employment agreement if they're going to be employees in the business. And then naturally, again, decisions being made, this needs to be agreed, whether it's going to be a vote. Obviously, there can be more than one founder or more than two founders, rather. There may be directors separate to the founders. What we've see a lot of is you've either got a joint system for decisions being made, or just a single founder makes the decisions with certain limitations. And that sort of brings us to our next point, where there's day-to-day decisions and key decisions. Day-to-day being operational. Are we going to be using Slack as a messaging channel or WhatsApp business? And then more key decisions, which are, are we going to launch our product? And those we do recommend to be joint decisions, just to sort of maintain a sense of shared ownership. Although I'll admit that's not normally an issue in the beginning of founders agreement. It tends to come up a little bit later on. And then there's the sort of basics around non-compete and confidentiality. There might even be a separate NDA that the founders need to sign. But this is a pretty standard contract. Similar to what we mentioned in the intellectual property section, one of the things we would ensure is that while the founder responsible for creating the product, in our example, might not be allowed to compete directly with the startup, we would recommend ensuring that they would still be allowed to perform their usual function, if that is software development, if they're no longer involved with the startup. And then just to wrap things up, I'm sure at this point it gets a little bit boring for some, but just if things do end, as all things do, sometimes it's best to have that process detailed in the contract. If not, there'll be a process for mediation that gets detailed. So depending on the jurisdiction selected, what form of mediation, arbitration will be used to settle a dispute, to close up the company. And sort of who would be the party to mediate that settlement if it hasn't been detailed in the contract. And that's a little bit of a case-by-case situation, whether you'd want to do it that way or not. Few representations. This is important. So just choosing the jurisdiction that it's going to be under. Obviously, our expertise is in England and Wales, but we have assisted with other ones. And then just a standard clause to say that amendments not made in writing would not be considered binding. And that sort of wraps up the agreement. And again, this is, it's not a watertight agreement by PandaDoc, but it's something that a lot of founders make use of because it's quick, it's easy, it's either low cost or free. But we're also able to assist with the drafting of these agreements when it starts to get a little bit more complex. Otherwise, we're happy to help with the review.